Would the court call number 19 on the calendar, State of Utah versus Maykela Cox?
Number 19, Ms. Cox.
We're here, first of all, to address bail.
The state's on notice and prepared to address that today.
Okay. So let's see. What is her bail at presently?
Her bail is set at $50,000 cash only.
Okay.
Ms. Cox does have a right for bail to be set, and with that right it is her right to have a reasonable amount of bail. At first glance, considering the number of charges that are before the court and the severity of the charges and the nature of the charges, $50,000 might seem reasonable, but looking a little bit closer, I think that that is an unreasonable amount of bail in this case. The allegations stem from when Ms. Cox was 8 years old through 17 when she was a juvenile. She's now 24, is that right? She has gone to college. She's spent some time at Utah Valley University, where she was president of some clubs. I recently saw a video of her trying to win Miss UVU. She transferred up to go to the University of Utah, where she was enrolled for this semester. She has dropped those classes because she's been obviously unable to attend. She's been living a productive life. These allegations are a delayed report of 7 years. She's been living a productive life for the past 7 years, not posing any danger to society. The police report and I believe the probable cause statement and the information mentions that she hasn't had contact with the alleged victims for quite some time. There is the two aspects that we consider when we're setting bail is the danger to society. That's what I've been speaking to, is that she has been in society and been a productive member of society and doing, I think, what we hope that young people her age would do, is go to college and be active in the community. She has a large support group. Many of them are here today. Those that could get off work, they're here on the front row. If they could stand up to show their support.
Thank you.
She's been involved in poetry, where she's been in a poetry club, a club of sorts, right? Just a very active person in the community. I think that any harm to the community that could be even fathomed could easily be protected against with a simple order from the court that she have no contact with any children, if that is the concern of the court.
Well, where's she currently? Is she currently living with a family, or is she living on her own, or what's she doing?
She is living.
I'm just currently living on my own.
Okay.
Going to the university, living in Salt Lake County.
Mm-hmm.
She's engaged to be married. Her fiance is here today as one of the people who stood up.
Okay.
As far as is ensuring that she be able to, ensuring that she return to court, a small amount of money can do that. So we would ask that the court make her bail bondable at the very least, but that it also be significantly reduced, that any of the two factors can be addressed with a much smaller amount of bail, considering those factors.
Okay. All right. Thank you. Mr. Johnson?
Yeah, Judge, the father of 5 of the 6 victims is here and would like to address the court briefly.
All right. That would be fine.
Keith Smith.
Okay. So would you like to come forward and?
Come on up to the podium.
All right, sir, if you'd like to state your full name, then I'll be happy to hear what you'd like to say.
Keith Walter Smith.
Thank you.
We have concerns with Maykela being back out in the community because of the potential impact of her being able to interact with the kids. We currently have 2 children that are up in the Salt Lake area at times going to school. One of them in the school that she has chosen to attend, they have images of Maykela up at the school right now, and she was very concerned about that. Created a lot of anxiety for her and doubt as to whether or not she wanted to continue to attend the university. Right now we feel like it would not be appropriate for Maykela to be out in the community till we're fully aware of what she's done to manage the problems that caused these crimes. So we're not comfortable with her being out right now.
Okay, thank you.
Thank you.
Thank you, Keith. Judge, I met with Keith and the alleged victims last week and went over kind of the procedures and things at the court and got their feedback on where we're at. As the court has seen, she's looking at 19 first-degree felonies. At least 4 of those are 25 to life, mandatory minimum prison, sodomy upon a child, and object rape of a child, even though these occurred when she was under 18. It's one of those two-edged swords. The kids waited to disclose, but also she certainly did not come forward at that time to disclose either. Judge, looking at this in the interest of justice, when you're dealing with 6 victims, I mean, the allegations essentially are that her brother-in-law and sister took her in because of her poor home life and abuse that she suffered. And out of the goodness of their hearts, unbeknownst to them, they were turning it over to a predator. And she ended up molesting, allegedly, 5 of their children when they were taking her in. And then the 6th victim is one of her sisters. And so, in the interest of justice, $50,000 cash, frankly, I'd ask for that per child. I think for all 6 is a gift. So I'd ask that it remain.
Right, thank you. Mr. Taylor?
No, I think that basing the bail on the severity of the offenses and not considering the factors that I've already mentioned is punitive only and would be presuming guilt prior to her being tried.
Well, we do presume guilt based on a probable cause standard when we set bail. I mean, we don't presume guilt, but guilt is established by probable cause. And so we're not really dealing with a presumption of innocence at the bail stage. There's probable cause to believe that she has committed these offenses, and so we set bail based on whether she is a flight risk and whether she is a threat to the community. Those are the 2 primary factors. So
I think I would just disagree that guilt is presumed at any level. I think that there is probable cause that a crime is committed, but that's not at all guilt.
Well, as I said, we're not presuming guilt. I changed my statement. We're not presuming guilt, but there is probable cause to believe that she committed these offenses, and that's the standard on which we set bail. So the presumption of innocence does not apply when you're setting bail. You see whether there's probable cause, and then you don't wrestle with the question of whether she did it or not. You simply set bail if there is probable cause, and that's based on those factors. Or you decide that there's no bail, or you decide that she could be released on her own recognizance. Those are the options. So,
right. I do agree with that.
Right. Okay.
What I was referring to is that because of the ease in which the court can place restrictions that would negate any of the risk to the community by putting in conditions upon her release.
Well, if people always obeyed the court's restrictions, and she very well may, but on the other hand, she's kind of a victim of the company that she's in right now. I mean, a lot of people who are, like we've seen today, they don't want to follow the conditions that the court places on them.
We have seen that today.
Right.
And she has no prior criminal history. She has no allegations that are within the last 7 years. So assuming that she's going to violate any condition that the court would put on, I think would be incorrect, is that we have much more evidence to show that she wouldn't violate any condition that the court would put on. She would be insured to come back to court with a lower amount of bail, and safety conditions that the court sees fit could be placed on her, that if she violated those, she would clearly not be entitled to any bail at any future point if that were to happen.
Right. Okay. Thank you. At this point, the court had set $50,000 bail, I think, on the basis that it did not believe she was a flight risk due to her ties to the community. However, otherwise the bail would have been a lot higher. Also, given her age, the court did not think that she would automatically go out and start abusing children, but on the other hand, there is a very real possibility based on her criminal history here in terms of this offense, which stretched over a long period of time, that she would do so. And so I don't really know anything about her psychological makeup right now, and the psychosexual evaluations are not 100% accurate anyway. But at this point, we don't know what she might do, and we don't know what she's been doing the last few years. Mr. Johnson is correct that had she taken responsibility for this when up front, before she became an adult, that number one, she would probably have been in the juvenile system and would not have suffered confinement. She may have been placed under some type of supervision. But number two, she would have had her been involved by taking responsibility. She would have been afforded treatment at that point. Right now, I think that you've got a lot of first-degree felonies here, and I think that $50,000 is way on the light side. And the only reason for that light bail is because I think she would probably appear in court if she were released. But I can't guarantee that she wouldn't have contact with her nephews or her nephew and nieces here, or with any other child. This is, this didn't stop when she was 12 years old. It kept going until she was, I don't know.
Allegedly it did.
Well, it kept going. There's probable cause to believe it kept going, Mr. Taylor. The court is not going to argue guilt and innocence here. She is presumed, not presumed, but she has probable cause to believe that she. So I'm not going to say that we ought to release her because she maybe didn't do it. Okay, we look at probable cause, and that's what we have here. So I'm going to leave the bail as
She
is.
addressed the court.
Well, I've already spoken, but she can address the court. But I've already made my ruling, so you can you can address the court, ma'am.
Your Honor, as far as the allegations, they are just that.
Well, there's probable cause to
I
believe that you
understand.
committed this. And you're right, when you get to trial, you're presumed innocent.
Right.
Right now, the court does not regard you, does not apply the presumption of innocence when setting bail.
I understand
The court has to state that you that there's probable cause to believe that you committed these offenses. That's how we do bail.
And I
Okay?
understand.
So I want to get away from this guilt and innocence argument. Okay? It's not applicable here for the fourth time. Okay? Anything else?
I was just going to say a lot of my friends and family have young kids. They've known me for years and have trusted me and continue to entrust me. And they have seen my character and my nature. And so that's what I was going to say as far as what your comment, as far as what I've been doing the last few years. I have been in rigorous therapy because of the abuse that I suffered as a child under the care of Tamil and Keith Smith, the victim's parents, the alleged victim's parents. And so for that, I would say that to my character, a lot of people can speak to my interaction with children and the positive community. A lot of these same individuals can speak to my character. I'm not here to tell you who I am or what I am. I am innocent, and we'll go through that with the trial. But I did want to let you know that I am not a monster or a heinous offender.
Well, and I certainly hope that's the case. I certainly hope that's how things turned out. But we'll see. Okay. All right. Thank you.
So as far as next date? what do
Yeah, we need to set another date. You want to set this for what? Another waiver, a preliminary hearing? What do you want to do?
There's a plea offer that's on the table until November 9th. The defense has had for a week or so, so
Okay.
you can go
Well,
till then. Or
wanna
if you just
set-
want to set prelim, it's up to you.
You want to set this on the 9th, or what do you want to do there, Mr. Taylor?
Your Honor, I'm actually not going to be available on the 9th.
You want to do the 16th, or what's your pleasure?
Your Honor, could we set it for a waiver hearing on the 16th?
Sure. Okay, so let's set this on the 16th at 1 for a waiver. All right, thank you.